Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3089, United States of America versus Curtis Jenkins, appellant. Ms. Getzel for the appellant, Mr. Burney for the appellate.
Ms. Getzel, go ahead when you're ready.
Good morning, and may it please the court, Celia Getzel for appellant Curtis Jenkins. I'd like to reserve 2 minutes for rebuttal. This case presents the straightforward question of whether the text of 3582 prohibits district courts from considering certain factors in determining whether extraordinary and compelling reasons warrant reducing a defendant's sentence. The district court believed that it lacked authority and discretion to consider factors dissimilar or incomparable to the guidelines criteria, including significant changes in the legal landscape. As this court already recognized in United States versus Kevin Johnson, district courts may consider arguments based on Winstead and any other grounds the defendant presents to justify a sentence reduction. The only prohibition on what may satisfy the standard is clearly articulated in 28 USC section 994T, where Congress explicitly stated rehabilitation of the defendant alone shall not be considered an extraordinary and compelling reason for a sentence reduction.
So you raise various arguments. Let's start with the commentary, the application note. Was the district court wrong to consider the application note as helpful guidance and expressly say that it was not bound by the application note?
Our position is that the district court can consider the commentary, but that given the posture of the commentary right now, the fact that it is application notes and the fact that it is not applicable means that the district court cannot be constrained by the commentary in the way that this district court was.
Well, but she wasn't. She said, this is helpful guidance. She expressly said she wasn't bound by the commentary, and she didn't simply look at whether the medical and family considerations were within the four corners of the application note. She looked to whether there were comparable medical and family issues. That seems pretty flexible.
She used the commentary to the exclusion of considering other arguments.
What did she not put aside? All right, so put aside the retroactivity and the Winstead issues for now, which are different. Just on considering the application note, do you think she gave it too much weight? Just on the medical and family points.
Our position is that reliance on the commentary is improper because of the reasons stated in Long, that it is not a policy, it's not a policy judgment by the United States Sentencing Commission of what constitutes the appropriate use of compassionate release in light of the First Step Act and recent changes. So our position is that the commentary is not appropriate for the court to consider. Had the court done what Your Honor just proposed, right, without excluding certain arguments, such as, for example, the court did not consider the long administrative segregation that
I'm sorry, didn't consider what?
The long period of administrative segregation that Mr. Jenkins was subject to because of his physical inability to work in a job that the BOP directed him to work at. He was in the SHU, which is solitary housing unit, for almost a year, 8 months, for no justifiable reason. And that was another reason set forth. And the court discussed it in the background, but then sort of ignored it in her analysis and turned only to his medical conditions and family circumstances. So it's clear from the opinion that the court was not addressing, felt bound, it felt constrained by the types and kinds of things listed in the criteria when those types and kinds of things are not prohibited. The court is not prohibited from considering those under the plain text of the statute or for any other reason.
The segregation on this point is what you're relying on.
Also, the court considered.
I mean, we've got medical and family stuff, which she did consider. You have the non-retroactive change in law, which is a different point we'll come to, and you have the Winstead and one other case, the intervening cases, which we'll come to. I'm just trying to figure out, is there anything else?
She appeared to believe that he had to be the only available caregiver, which is language that comes directly from the guidelines criteria,
right,
in order to satisfy a standard based on family circumstances. So that those would be other indications that she felt bound, constrained, or tethered to the guidelines commentary.
All right, so your next major point is the intervening legal changes. It's one statutory and two cases. As to the statute, why isn't the simple answer, there's nothing extraordinary with prospective application of new sentencing statutes, and that's exactly what Congress mandated here.
The problem with that, Your Honor, is that that's putting a categorical bar on something where there is none. So Congress...
It's the district court's explanation why prospective application of a new statute is not extraordinary. What's wrong with that? Well,
that's basically saying that's the same thing as saying in no case. And because that's not, as the court in Ruvalcaba explained, that's basically not making an individualized assessment that's required under the statute, 3582. The court should make an individualized assessment of the impact of whatever prospective change in conjunction with the totality of the circumstances.
Can never say this kind of thing is not exceptional.
The court can find something not extraordinary or compelling in a specific case. That's not what the court did here, though. There would be nothing wrong with the court saying that I don't find this change in the law that Congress applied prospectively to be extraordinary and compelling to help show the defendant's extraordinary and compelling reasons, plural, warrant reducing this particular defendant's sentence. But that's not what the district court did here. The district court thought that she lacked authority.
Ms. Katsas, you're talking about the anti-stacking provision, is that correct?
That's correct. His sentence was based on a 45-year mandatory minimum. So
what do you mean by based on? You didn't plead to more than one covered offense. There was no stacking.
The plea was basically a Hobson's choice based on the stacking in the indictment.
This is your argument that the plea was tainted by these overhang.
That's correct, Your Honor.
Okay, well, that's a non-starter for me. If we start getting into what's overhanging plea bargaining, there's no end to it.
It's not just the prospective change in law that impacted the harshness of Mr. Jenkins' sentence. It is also the fact that he was subject to 22 to 27 years regardless. So on the plea that he took, his guidelines range was 22 to 27 years because of his career offender
And this affected his negotiating position and the outcome of the plea bargain.
And
Right.
the imposition
I don't doubt
of the
that could happen, but I don't think it's a judicially manageable consideration. It's going to be something that's going to be not limited just to a change in statutory law, for that matter. Lots of things might overhang the plea negotiations in a way that burdens the defendant.
And that's why the district court has broad discretion to consider things in particular cases. That's why the district court can look at the case as a whole. The court originally sentenced the defendant. It's exactly what the court said in Long. The court has broad discretion to consider in an individual case.
So the defendant mistakenly thought his mother was dying of cancer and then pleads to something wouldn't otherwise have done, and then it turns out she's not dying or what have you. I mean, lots of things can affect the bargaining position.
We agree, Your Honor, and that's why in that particular case, if a judge found that that wasn't an extraordinary or compelling reason that contributed to the totality of the circumstances that warranted a sentence reduction, there would be no abuse of discretion there. So here, the problem is that the court would not consider, it thought its statutory authority was restrained or that it had no choice. No authority. And the language that the court uses.
That may be, but I understand your point about feeling constrained. What I'm focusing on is what it felt constrained not to consider, which is to say this taint on the plea bargain. So I have your point.
So our argument is that the district court is in the best position to consider those arguments and has broad discretion, and that we should trust district judges to exercise their discretion, and that at some point there will be a quorum in the Sentencing Commission, and the Sentencing Commission, this is only a temporary moment in time, the Sentencing Commission will explain the appropriate use of 3582 and promulgate guidelines in light of the current events and in light of the change in the statute. And until that happens, a district court is not prohibited from considering changes in the law.
On your Winstead Gordon arguments, those are arguments not about intervening legal change in the sense there's a new statute, nor about the typical compassionate release case, which is an intervening factual change, which makes the defendant a sympathetic candidate for release. They are arguments about legal error in the sentence itself. District court just made an error in the sentencing. Why is that appropriately subject for compassionate release as opposed to just a plain vanilla 2255 argument? You're collaterally attacking the sentence. You're not arguing that something has happened post-sentencing.
So it may be proper through a 2255, but that's not. But first of all, Mr. Jenkins wasn't moving for compassionate release based solely, and compassionate release is not actually, those are not actually words that appear in the statute.
Fair enough. Fair enough. But that's usually what we think of.
Agreed. I understand, Your Honor. So it is a sentence relief mechanism. It was contemplated as a safety valve. There is nothing in the statute or in 2255 that prohibits a court from considering the original sentence in deciding whether to reduce a sentence. So there is no textual bar for considering it.
There are a lot of cases that stand for the proposition that if you're challenging the duration of confinement reflected in a sentence, you must bring that claim exclusively through habeas, and 2255 is the reasonable substitute for habeas.
Mr. Jenkins was not challenging the lawfulness of his sentence. He was not seeking to have his sentence vacated and have a resentencing. He was not challenging the constitutionality of his sentence. He was.
Well, except, your Your Winstead argument is precisely a challenge to the lawfulness of a sentence.
Respectfully, Your Honor, we weren't challenging the lawfulness of a sentence. We were asking the district court to consider the sentencing error in considering whether she should reduce the sentence. We're not saying that under 2255, if the sentence is unlawful or unconstitutional, the court must correct it. There's no discretion. Now, there are procedural bars, but if the sentence is unconstitutional and unlawful, the district court must correct it. That is not what 3582 is a totally separate procedural mechanism. It's a sentencing modification. It's a relief. It's a safety valve. It was contemplated as that. And so there is no reason why a district court is barred from considering the totality of the circumstances, including Section 3553A factors, when the court is considering whether extraordinary and compelling reasons warrant reducing a defendant's sentence. Because the Winstead error would be viewed under 3550, like courts that have said that district courts cannot consider changes in the law, have said that courts can consider these changes when they get to the 3553A factors. But the 3553A factors overlap with reasons that can be extraordinary and compelling. The 3553A factors are all encompassing. They include the personal history and characteristics of the defendant, rehabilitation. Congress contemplated that those factors, including what the proper sentence would be considered as part of the extraordinary and compelling reasons analysis. And that's clear from its prohibition of rehabilitation alone being an extraordinary and compelling reason.
Do you think his sentence was lawful?
Your Honor, that's not what his sentence was imposed based on a career offender range that did not apply. So to say something is lawful or not lawful in the context of habeas and various other things is a very complicated matter. So he hasn't brought a habeas motion. He's not saying that he must be released from his sentence because it is unlawful. Here, he is saying that a totality of the circumstances warrant reducing his sentence and asking the court to consider the error that was made at sentencing.
When the district court imposed the sentence, did the district court commit error?
Yes. Because Winstead says the district court committed error.
I mean, that sounds an awful lot like you're challenging the legality of the sentence.
We're not challenging the legality of the sentence. We didn't bring a 2255. We didn't say that the court...
I mean, maybe part of the reason you didn't bring a 2255 is that actually you waived your right to bring a 2255 as part of the bargain that you struck. And the collateral attack waiver in his plea deal seems all the more reason to be somewhat skeptical now of whether compassionate release statute allows you to, in effect, do the same thing.
Respectfully, the district court could consider those arguments in finding that in this particular case, Mr. Jenkins' sentence or the reasons that he proffered are not extraordinary and compelling. But it can't categorically bar considerations of all of the original sentence in determining whether extraordinary and compelling reasons warrant a sentence.
You think a waiver of a future compassionate release motion is something that could be put into a plea deal?
Your Honor, that the DOJ currently has a policy that it will not do that because the compassionate release statute is a relief mechanism. It's a sentence reduction mechanism. And district courts can see through.
Sorry, go ahead.
District courts have the ability to see in individual circumstances to determine whether they think something is unusual and convincing to them that compels them to reduce someone's sentence and doesn't. But that's not what happened here.
Do you think DOJ might take a different position on that if we were to hold that the compassionate, any legal error in the sentence can be challenged through compassionate release on the theory that you're not saying it compels relief as a matter of law, you're just saying it's a factor to be considered?
Your Honor, we're not asking the court, and that's not the decision before the court, to say that all legal error can be challenged through compassionate release. There will be a...
That's your theory.
Our theory is that the court must consider a totality of the circumstances. It can't...
Including any legal error in the sentence.
Including any legal error in the sentence as part of a totality of the circumstances analysis. So we're not saying that, and perhaps, I mean, courts have found that legal error alone with nothing else cannot be extraordinary and compelling. But to say that legal error in all cases as a matter of law cannot be extraordinary and compelling it prohibits authority where there is no bar of authority in the statute. So there is no bar in the statute for courts to consider legal error. So the courts that have said that courts can't consider legal error have invented a prohibition, a categorical prohibition, and they shouldn't do that because the Sentencing Commission is tasked, and it's in the best position to study the appropriate use of compassionate release and create guidelines that explain its appropriate use. And it hasn't had an opportunity to do that, and it will do that. The court, by doing that, these other circuits have usurped the discretion of the district judge and of the Sentencing Commission.
Anything else, Judge Walker, Judge Ginsburg? Okay, thank you. We'll give you a few minutes on rebuttal. Good morning.
Good morning, Your Honor. May it please the court, Kevin Burnett of the United States. I'd like to begin with the long issue and the standard, because that's where we began with appellant's argument. And just first, the trial court clearly demonstrated that it understood the correct legal standard and that it did not consider itself bound by Long. And we have the relevant quotes in our opposition. I'm not going to belabor this point unless there are any questions. But it's laid out very clearly and very early when it's laying out the legal standard. The court says on JA 243, for instance, it recognizes Long, it cites Long, it cites other cases that have recognized that 1B1.13 is not controlling, but then says even though it's not binding, I can still inform the analysis. And then the court goes on 244 of the joint appendix to say the court finds it useful to consider the suggestions as general guidance. So the court clearly understood what the legal standard was. The court does need to start from somewhere. I mean, circuit courts have been very clear that extraordinary and compelling does not mean that district courts can just do whatever they want. And so that's what the court was doing. It was starting from somewhere. It was just using the commission guidelines as sort of a starting point to reach the very arguments that appellant was making regarding his health conditions, regarding COVID, regarding his mother, and then moving on to the sentencing issues as well, which we'll discuss. But I think
it was very fact bound on the family and health issues. It then said categorically, I can't or shouldn't consider the intervening statute that was made prospective or the two intervening judicial decisions. Right. So how do you answer your friend's argument that those considerations should have been assessed case by case? Throw everything into the hopper, I guess. How bad was the sentencing error versus how bad was his disease?
Right. So we disagree with appellant on that. We don't think that the district courts in general should consider those factors. I would say too, just as I start this question, I think that the district court was doing two things. And so in the section that Your Honor referred to, And that's why we briefed it the way that we have. We're trying to tease out both of those things. I think the district court is, first of all, saying, I shouldn't be considering these things. These things are not appropriate for compassionate release. But the district court is also engaging with appellant's arguments about how harsh his sentence was. And she goes into some detail about that. She talks about what she said at sentencing. She acknowledges that perhaps it could be considered harsh. And she goes through the exact numbers. So she goes through the fact that it was a C1C plea. It was 96 to 144-month range. She sentenced at the bottom. And so I think she's saying, she's also basically saying, even if I thought that these were proper considerations, they're just not enough to show extraordinary and compelling circumstances in this situation where he was not sentenced as a career offender. He was not sentenced under ACCA.
So where do you get that alternative? I didn't read it that way.
So if you go to the order, which is at,
I have it.
right, at JA, starting at JA 245.
Right. Sentence itself was largely driven by the 60-year mandatory minimum.
Right, which I think that's a typo. She needs 60-month mandatory minimum. Yeah. And then she goes on, the grounds conclude that the original sentence was harsh. She acknowledges that his circumstances of his incarceration, appellant was talking about solitary confinement. She seems to be acknowledging that as well. And then she goes on to say, as I think this is the point Your Honor is making, says that the compassionate release statute was not intended to serve as a second chance, and there's more language along those lines. Right. Then in the next paragraph, she's talking about an agreed 96 to 144 months of incarceration. So I agree with Your Honor that she is more squarely saying, I shouldn't be considering these factors.
And she may well be right about that, but it does seem like it's a categorical, that part of the analysis is categorical.
That's correct. I do think she's definitely saying that. And so just starting on that first point, the government agrees with that. And I think the government would point this court to Andrews. That's a very good case on that, but it's not just Andrews, it's Jarvis, it's Thacker. There are other cases.
This is the point that you have to go through 2255 to challenge.
That's definitely part of it. And Thacker says that squarely. So we would agree with that.
Do you see that in the opinion?
In Thacker, yes, it does say that.
In the district judge's
opinion.
No,
the judge did not discuss 2255.
No.
It's an alternative. But we would submit that is an alternative that defendants can't avail themselves of.
I mean, it may be implicit in her statement. It may follow from her statement the compassionate release statute was not intended to serve as a second chance to address the sentence. I mean, the corollary of that is that kind of argument. She says categorically, don't raise it through compassionate release. The suggestion might be do raise it through 2255. I mean,
yes,
it is pretty cryptic.
That's right. I acknowledge that. She doesn't mention 2255 explicitly.
Is that in Andrews, the case she cites? Does Andrews talk about 2255?
I don't believe so, but Thacker does. And I think the district court cited Thacker as well, if I'm remembering correctly.
It seems to me what you just said about the district judge is not inconsistent with the defendant's argument here, the petitioner's argument here, that this is not an attack on the sentence. Attacks on the sentence have to be rooted through 2255, let's say, but something that says, well, look, the sentence was lawful. I understand that. I'm not saying it was unlawful. It was when it was imposed. It hasn't become unlawful. I'm asking for compassionate release with respect based upon post-sentencing developments.
Well, I think
I think that there's a lot of references around these cases to the point that it is about post-sentencing developments. That's why the department wouldn't rule that out in an agreement, right? I mean, it wouldn't make sense to say you can't raise something that hasn't yet happened.
Well, I think yes, the compassionate release statute inherently is about post-sentencing developments, but I think cases like Andrews and Jarvis and Thacker are suggesting those developments do not deal with the length of somebody's sentence. So, for example, a post-sentencing development that the compassionate release statute would be designed for would be terminal illness, for instance.
Yeah.
Health conditions like
Right.
COVID.
Right.
And here, of course, we would submit, we've briefed it this way, that appellants' health conditions did not rise to that level, right? And the district court explains, I think, why that is. And I won't spend much time on that. But cases like Andrews and Thacker and Jarvis, and there are others, I frankly ran out of space in our opposition, but there's Hunter, there's a case in Crandall in the Eighth Circuit. There are other cases, other circuits have made clear that there's nothing extraordinary about later law that makes a prospective change in career offender status, what qualifies. There's nothing extraordinary about that. I think Andrew says that very squarely. In fact, the ordinary rule is that it doesn't apply retroactively, it applies prospectively.
Well, with respect to the sentence, to the lawfulness of the sentence.
Correct.
Suppose something is decriminalized after the sentence is imposed, the person is serving the sentence. In other words, society has taken a different view, changed its view of the nature of the conduct. That strikes me as something that fits so nicely with the 3553 factors. Asking about whether this is whether the sentence is consistent with needs for deterrence, and et cetera. There are at least two factors that would seem to take that directly into account. But you're saying can't raise it.
Well, they could raise it if they establish some other independent, extraordinary, and compelling reason. I just want to, just focusing on the decriminalization hypothetical, that specific one. Congress almost always, when they decriminalize something, they have a retroactivity provision in the statute.
Well, deal with my case.
Right, but let's say that they didn't, right? So in that case, the court could consider that under the 3553 factors, but that wouldn't be an extraordinary and compelling circumstance. So the defendant would
can't get there unless it is, right? Can't get to the 3550.
Right, unless they show
unless something is.
Right, unless there's something else, some serious health condition or something like that.
Well, or maybe this.
Well, I mean, I think our position would still be that that's not an extraordinary and compelling circumstance. But I also think, I understand your Honor's point. Likely it would not become an issue because Congress would make some sort of.
Yeah, I understand. I'm not aware of any other situation, maybe you are, where the motion is not a habeas motion, but also is not viewed as an attack on the Senate.
Yeah, I'm not aware of any other situation like that either.
I think this is unique in that regard. There's no opportunity out of bounds to attack the legality of the sentence. It's not on the table.
Well, through this mechanism, yes. But again, we would say that you could attack it through a 2255.
I understand that.
But yeah.
I'm saying through this mechanism, it is not a threat to the legality of the sentence.
Right. I understand. I see I've run out of time. I don't want to, take up any more of the court's time. I can respond to any other questions. And if not, I'll just conclude there. We would just ask that you affirm the district court's order. Thank you.
Thank you.
Oh, I guess, tell me 1 second,
Sorry.
counsel.
I'm back.
In your brief, I didn't see you taking a position on the circuit split. Is that correct?
Well, we note it in a footnote.
That one that says in the alternative?
It's, I can point your honor to it, but it's discussing these cases like Jarvis, Thacker, Andrews.
I'm sorry, this is on the question of intervening statutes that are by their terms prospective or intervening judicial decisions that, of course, are retroactive?
We definitely deal with the first.
I thought isn't there's a split on the first question, right?
That's correct. And our position is basically these cases are right. These cases provide even more basis to affirm the district court's order.
And that's in your brief?
Well, I can bring up the exact language and I'll point your honor to the footnote. Okay, it's footnote 5. It starts on page 20.
Yep.
So the cases, the circuit split that the appellant is focused on, those cases, Andrews, Jarvis, and Thacker, are dealing squarely with 924C stacking. That was the issue in those cases.
Mm-hmm.
And we say because no stacking occurred in this case, this court need not address the issue here. And this also, by the way, gets to your Honor's question about the fact that he didn't receive these career offender ACCA sentences. But we then say these decisions do, however, provide further support for the proposition that the district court did not err in rejecting these arguments. And then we say, well, instead, the arguments are misplaced on other grounds. So that's why I want to convey to the court that I think we have two independent arguments for why the district court here was correct.
Ordinarily, I think you would agree we do not, as a practice, resolve a matter that we have to resolve, even a statute.
Right. So, all I'm trying to convey is I think there are two different ways the district court's decision can be affirmed on this. The first is Andrews, Jarvis, Thacker, because even though those did deal with 924C, there's a lot of broad language in there about how there's nothing extraordinary about a change in these types of considerations.
Even with intervening cases?
Even with intervening cases. So that's one way this court could affirm. The other way this court could affirm is dealing more what Judge Ginsburg's question was earlier. He wasn't sentenced under these provisions, right? And I do think that the district court understood that, and the opinion, the orders teases that out, even though I acknowledge, as I was responding to Judge Katsas' question, that it more squarely seems to be saying I shouldn't be considering this.
Let me send a message back to the department. As I understand it, in a circumstance like this, you're not obliged to observe the formalities, some of the formalities that we ordinarily expect under our rules. The defendant is excused from that. The petitioner is excused from that as well. It would still be useful for the court if the government did have such things as a summary of its argument, a table of its cases.
Understand, Your Honor.
Thank you.
I'll take that back. Thank you.
Thank you.
I just want to make 2 points quickly. One about the government's arguments and its lack of arguments, and one about addressing Judge Ginsburg's question about other statutory mechanisms. First of all, both of the government's positions that it just took, the first, that the court should follow Jarvis, Thacker, and those cases, the government did not brief on appeal. The second position that the government takes, that he wasn't sentenced under these provisions, the government did not brief to the district court. So the government never presented the arguments that it makes in its brief here to the district court, for the district court to consider whether
we can affirm on any ground supported by the record.
That's correct, Your Honor, but
the district court, regardless of whether or not there was an alternative case-specific holding, there's clearly a holding that, as a general matter, we shouldn't be considering intervening legal changes.
That would be the government's first, the argument that the government is saying where the court should follow Jarvis and Thacker, right, where it didn't brief that on appeal. The argument that the government did brief on appeal was that there are no extraordinary and compelling reasons in this case, because it claims that there was no prejudice. He wasn't sentenced under these statutes. It didn't say that in the district court. All it said, it only addressed his medical issues in the district court. And the second thing to answer Judge Ginsburg's question is that 3582C2 provides a sentence relief mechanism. Section 404B provides a sentence relief mechanism. The inquiry isn't quote unquote out of bounds. It's discretionary. So it's discretionary, and the Sentencing Commission is tasked with determining the appropriate use, and it will, and courts will be bound by that. Thank you.
Judge Ginsburg, anything else? Thank you very much.
Thank you.
Case is submitted.
Case number 16-1447, Racing Enthusiasts and Suppliers Coalition petitioner versus Environmental Protection Agency and Michael S. Reagan. Ms. Broom for the petitioner, Ms. Chen for the respondents.
Ms. Broom, please proceed.
Good morning, Your Honors, and may it please the court. My name is Shannon Broom, and I represent the petitioner in this case. I would like to reserve 4 minutes for rebuttal, please. Thank you. I will cover in my time 2 primary points. First, why this case is important, not just to my client, but to people across the country. And second, why EPA's action here constitutes a breathtaking effort by the agency to substantially expand its authority with no basis in law and wholly unsupported by the record that the agency put forth. It is arbitrary and capricious. And of course, I'll answer any questions that the court may have along the way. First, motorsports are part of the fabric of this country. We need to look no further than the Formula One race in Miami last weekend to see who participates. 250,000 people were there in person, millions watched on TV. And unlike football, the spectators of the sport often also are participants. They are racers themselves.
I ask, just kind of as a background question, what have racing enthusiasts been doing since 2016? Are they still buying all the parts that they used to buy? Are all those parts still being sold, or are these races still going on?
Right. Well, races are still going on all across the country, but EPA launched starting in 2016 after it issued its final rule. That's when it launched its enforcement initiative against the small businesses and other companies and some individuals, although we haven't found many cases at all.
It's the district court case that you cite several times.
That's one. There's an entire initiative. They have, probably 50 cases going.
So would I be right to say that companies that used to make and sell parts are no longer doing that?
Yes. So there are several enforcement actions ongoing. Some, I imagine some people are continuing.
Maybe this doesn't matter. So I'll drop it after this one last try, but I'm not asking what DOJ is doing. I'm asking what manufacturers and sellers are doing. Has their behavior changed at all?
Yes, it has. Many have stopped selling because of the threat of the EPA enforcement and the cases that they see, and many are subject to enforcement, and EPA brought an injunction against Gearbox Z, and others are looking at that, and they have stopped and been deprived of the ability to sell their product.
What if a racer just changed one small part of the emission system? That's all it changed. And they said, now it's a race car. Would they have broken any laws?
It depends on how they use it.
Let's say that let's only use it on the racetrack.
Then it is outside the ambit of the Clean Air Act. It is
but on your view, the amended regulations.
Under the amended regulations, right. So under EPA's statement in the preamble, EPA's view would be that is illegal and that they are violating the law.
I don't really care about preambles. So regulatory text. What text in the new regulations do you think makes it illegal to take a regular17 and adjust it into a race car?
Right. So in 85.1703 A, that used to say that the indicia is that vehicle exhibits features which render its use on a highway unsafe, impractical, or highly unlikely. Such features including but not being limited to tracked road, contact means, etc. And now EPA has changed that to say prevents the use on the highway. So that's one. So they have changed it so that it's no longer a use-based, you have to prevent the use. And it also, back to your question on the impact, people would need to even, anyways, that I think that I covered it earlier.
On the safety modification, clarification, whatever label we want to give it, how are you injured by that from an Article 3 standing perspective?
So my clients would now have to track and have increased compliance costs in order to track how the vehicles are being used and that they comply with the safety exemption. And that's a significant cost because the way that this industry is set up, it's a vertically integrated industry. So you have manufacturers, distributors, and retailers. And the distribution system is a complex electronic distribution system that is a centralized database that people subscribe to. And you have to, the ability for someone on the manufacturer side to trace through that system to how a part is actually being used would impose substantial new compliance costs.
Where in the record would I find that you've laid out those compliance costs so that I can find that you've demonstrated standing? And if it's easier to come back to it in rebuttal, if the presiding judge allows, that's fine by me.
Well, Mr. Pooley stated in his declaration that he did have increased compliance costs. So that is in Mr. Pooley's declaration. I think it's in paragraphs 11 or 6. And we'll be happy to supplement on that issue if the court would like that. EPA did not question that, so we didn't add any supplement to that, but we're certainly able to do that.
Sorry, increased compliance costs or just reduced sales?
No, it's in there.
It's compliance costs and reduced sales, but increased compliance costs. They have to, under EPA's view of the world,
we'll check it. Short affidavit, but maybe I missed it. I thought it was about reduced.
It's paragraph 10 on page 3.
Yeah, I apologize for misciting the paragraph.
Frankly, except what you said about the regulation, changing in the regulation to preventing use on the highway, I haven't seen anything in the record to support anything else you've said today, including the Pulley Declaration. There's some, that's totally conclusory. We don't know anything about what people from this, about what people are doing or what the effect is on the, your member here, I guess it is, Mr. Pulley. This seems to be, you seem to have assumed that somehow we would be, just taking into account the world of automobile racing, about which I know nothing.
Well, our brief included several references to information about the industry, and I guess you're making my point in many ways.
I'm looking for some evidence about this situation, and I'm not finding any. I mean, the allegations are broad, and they're not supported with any exhibits or anything that would flesh them out so that I know what's going on. The sales may be down, but it doesn't say why or what people do as a result, or what they do when they do buy these defeat parts and what they're doing when they don't. It's entirely vacuous. And there's nothing other than the Pulley Declaration on which to rely. Or is there?
So, Your Honor, I think it is self-evident that if EPA says you can't sell parts and people have been selling them, that they will not be able to sell them anymore and they will be injured by that.
somebody who can come in and say, that's what's happened and was here affected me, in some way that we can actually, make sense of, rather than just saying, that's it, it's affected me.
Well, I mean, we would be happy to provide a supplemental briefing on standing. Mr. Pooley can demonstrate that his sales are down. We could get other REST members to provide additional.
We used to entertain supplemental papers on standing until 30 years ago, and Sierra said it's got to be in your first filing with the court, first substantive filing with the court.
Well, it is in the first substantive filing, Your Honor, and I recall back in the E15 case, I believe it's the Chicken Council case in I want to say 2013 or 2014. Your Honors did have supplemental briefing on standing in a similar issue where the grocery manufacturers were claiming injury from the renewable fuel standard case.
I'll have to see why we departed, if we did, from our practice in that case.
But I mean, I think that it is clear that Mr. Pooley has submitted an affidavit that says, and under penalty of perjury, that he has been injured in his sales and has experienced increased compliance costs. And increased compliance costs have traditionally been considered to establish standing. And so, I'm not exactly sure what the court would want beyond those increased compliance costs. He has to track, EPA is saying that he has to track and show that they were necessary to prevent the operation on the street.
I guess what we're lacking here is anything to tie this to the safety requirements.
Right. Well, even the SEMA comments that were on the record in the administrative rulemaking stated that there were adverse effects on the industry, and that is in the administrative record. And those comments are in the JA. I don't have it, that page.
I think, isn't your position is on this point, it has to be that it is self-evident, which is one of the exceptions to the rule Judge Ginsburg is citing. It is self-evident that in order to convert a motor vehicle into a race car, you remove a bunch of safety features. And I don't know, maybe it is to racers, but I didn't know that when I started prepping.
Oh, also, if the rules change the baseline, then maybe you don't, and racing is simply quite as fast as it used to be.
I'm
That
sorry.
would be an injury, right?
Pardon me?
Oh, I was going to ask Ms. Broom, but what you just described, would that be an injury if it prevented race car drivers from driving as fast as they want to?
See why, as long as it affects everybody.
Right. So there are things that you have to do in order to convert a car into race car, and we do list those in our brief. Things like removing the seats, it's not just emissions. There are a number of indicia, but part of it is emissions because the emission controls reduce the power. And so and it's not just removing them, but replacing them with the parts that make the vehicle function. And so in that case, those are the parts that are being sold.
The regulation challenging is all about safety features. So you sort of have to connect your interest as a seller of parts for race cars, motor vehicles that are modified to become race cars, to this safety feature regulation, which is maybe not so obvious to me.
don't think
Yeah,
the county actually had it.
I'm not sure. Was that question to me? I wasn't able to hear it entirely.
I didn't have a question. You didn't miss anything.
Okay. But I guess I'm out of time, but I would like to.
Let me ask one question, Ms. Broom. What's your response to the suggestion that the preamble doesn't do any work?
I think the preamble states EPA's position, which was the first time EPA ever stated publicly that it is illegal to convert a motor vehicle into a race car. And they stated there, once a motor vehicle, always a motor vehicle view. Back in 1965, when the Clean Air Act was enacted, there was regulated and unregulated. Motor vehicles were regulated and everything else was unregulated. And then in fast forward, and EPA accepted that. The non-road engines, the tractors, the snowmobiles, and all that stuff were not regulated, and so were competition vehicles not regulated. And that was how the world operated until 1990, when Congress decided to add non-road engines into the mix and regulate them. And non-roads are tractors and snowmobiles and other farm equipment and that type of thing. And Congress said, well, we've got to make sure that it's clear that we're not bringing in competition vehicles. Yes.
Oh, yes. I mean, that's a very odd thing for you to be challenging, because the preamble statements that you're focused on are associated with the agency's declining to adopt a proposed regulation that would have made it crystal clear that you can't convert a motor vehicle into a race car, and declining to do so because the agency says we're not anti-racing. So, I mean, that aspect of the rule doesn't hurt you. That's actually helpful to you.
Right. That is helpful, but then they created kind of a sleight of hand there, and they also said, but this change isn't needed because that's what it always was.
Maybe, but that might be an argument. That sleight of hand aspect of this might be an argument why adopting the change to the definition of motor vehicle is arbitrary, but it's not an argument that you were harmed by the failure to adopt a proposed rule that would have hurt your clients.
It's what they said. The final action that we challenge is this definitive statement that they made in the preamble. And there is a lot of case law that we cite: Whitman versus American Trucking, Appalachian Power, Crop Life versus EPA, that clearly establishes in the DC Circuit that the preamble statements, when definitive, constitute final agency action. I mean, even a guidance document can be a final agency action. That's at the Appalachian Power case.
If there's any final agency action, it was the decision not to do anything.
No, it was respectfully, Your Honor, no, it was the statement that it is now illegal to convert race cars in motor vehicles into race cars, into competition vehicles. That is the final agency action. And we know it is because now EPA said in the Gearbox Z briefing that it had effectuated that change, that it made a change in the law.
It's bringing cases that it could well have brought before. It seems to me what you've outlined is that for a long time they decided not to enforce the regulations as they were since 2011, and then they decided they would.
If this was an exercise in enforcement discretion, we have numerous indicia in the brief that show that that EPA had never taken that position before. And we have the Congressional Research Service report. We have EPA's Green Racing Initiative. We have 50 years of conduct since 1965 where they never did anything. And if that was, and it was happening right in front of them, EPA was engaging with the racing community all along. And if they thought that that was illegal, they should have said something. And if you look at what they cite in their brief.
No, administration's enforcement policy changes as long as it's consistent with what the law authorizes.
This was not an administration change
Policy change.
issue. It wasn't an administration policy change issue because if you look at it, it started at the end of the Obama administration and it continued in through the Trump administration. So I don't think it's fair to say that that's the case.
Just saying policies change. One reason is sometimes administration changes. Sometimes they simply reevaluate and change their position without a change of administration.
Can I ask you one?
That's not what happened. This was not a 50-year exercise in enforcement discretion. If it was, when EPA exercises enforcement discretion, they make a big deal about it. They blast it from the rooftops. You look at the COVID-19 situation, they issued an enforcement discretion policy and they listed all the criteria that you had to meet. If EPA really thought this was an exercise in enforcement discretion, then they would have been talking about it right and left. Instead, what was happening is what the law was, which is that competition vehicles were not regulated under the motor vehicle provisions. And EPA never thought that they were.
Can I ask you just briefly on the other regulation that you challenge, the competition exemption? How are you harmed by that one? There are two provisions in this regulation. One of them applies to manufacturers of motor vehicles, and your clients are not manufacturers. And the other applies to people who make changes to non-road engines, which, I don't know, your clients may or may not do that, but the changes to that regulation are wholly cosmetic. So what injury flows to your clients from these changes?
Can you just help me?
This is 40 CFR 1068, which has an A and a B, and A is the rule for manufacturers and B is the rule for modifiers with wholly cosmetic.
1068.235.
Yes.
Yes. Okay. Thank you. On that one, what EPA did there is they said the following provisions apply for non-road engines and equipment, but not for motor vehicles or for stationary applications. There they have taken the position and you see what they said they were doing in the Gearbox Z brief. They say that provision effectuated their change to make it illegal for motor vehicles. That is how EPA has interpreted that provision since that time. That is their position.
Look at A. It is addressed to people who produce non-road engines or equipment.
Any of those in the petition balanced group here?
Excuse me, Your Honor. I have just the excerpted provision in front of me.
My understanding is your declarant represents sellers in the aftermarkets, not motor vehicle manufacturers.
Correct. We also have, that's our declarant. We also have members who are manufacturers of aftermarket parts.
That's useful to have had something from them.
All right. Well, I can tell you, it seems to me that that clause A doesn't seem to apply to, at least to Mr.
Fully.
Mr. Pooley or his organization. Anything else, Judge Walker, Judge Ginsburg?
No, thank you.
Okay, thank you.
Thank
We'll
you.
give you minutes on rebuttal,
Thank you.
and you'll hear from the government whenever you're ready, Ms. Chen.
Thank you, Your Honor. Good morning, and may it please the court. Sue Chen for the United States. The Clean Air Act prohibits tampering with emissions controls on motor vehicles, even if they're used solely for competition. That follows from the statute's text and structure, through which Congress set up a program to regulate motor vehicle emissions. That program treats motor vehicles used solely for competition no differently than other motor vehicles. And Congress chose to stick to that approach even as it exempted other kinds of vehicles from the prohibition against tampering with emissions controls. I'd like to start with the statute and then briefly address why there was no new interpretation in 2016, and finally respond to petitioner's point about the impact of this case. Under the Clean Air Act, motor vehicles used solely for racing are still motor vehicles, and they're still subject to the tampering prohibition. The statutory motor vehicle definition has no exit ramp based on competition use, and that, of course, stands in sharp contrast to the non-road definition, where Congress did put in an exit ramp. But I want to be clear that the non-road definition does not apply to this case, because everybody agrees that the vehicle that we're starting out with is a certified motor vehicle. And the question is that vehicle still a motor vehicle when you use it solely for competition? The motor vehicle
Seems to me the statute is ambiguous. It's key to design, but it doesn't address any question of redesign, and it doesn't address whether we're talking about design at the moment of manufacture or at any later point. Seems to me the statute could readily bear either meaning.
So the design that matters in the statutory scheme is the automaker's design, because that's what determines whether what you have is a vehicle and is a motor vehicle, and that is regulated under the Clean Air Act. But for us to win, you don't need to hold that the design of a motor vehicle never changes, because the kind of competition use and conversion / redesign that the coalition is talking about it does not exempt you from the tampering prohibition. And let me just specifically address the redesign question. I think there are three big problems with it. The first is that I think it's significant that Congress did not expressly exempt competition conversions from the tampering prohibition, even as they've exempted alternative fuel conversions, as we just discussed in our brief. The second problem is that this redesign theory would lead to an outcome that even petitioner concedes is wrong. So the way I understand the design theory works is that you make all these modifications to your motor vehicle, you add the roll cages, you add competition cameras, and it becomes something other than a motor vehicle. And that it becomes, I guess, what they call a competition use only vehicle. And at that point,
at some point, the changes are substantial enough to impose on the object a new design.
Well, let's just assume that that's true for the second. At that point, the theory is that you can tamper away with that vehicle's emissions controls, but you would also be able to drive that vehicle all over public roads. There's no use-based limitation to the redesign theory. And the problem there is that on page 12 of the opening brief, the coalition says that if you drive your race car on public roads, it's still illegal to tamper with them. So that's a big problem with that theory. The other problem is that I think it leads to this.
Why wouldn't what you just said make it, I guess, legal to drive a Formula One race car that was manufactured as a race car and not compliant with emission systems? Why wouldn't what you just said make it legal to drive that on the road?
Well, the Clean Air Act does not regulate driving.
But if your theory is once a motor vehicle always a motor vehicle, why doesn't it stand to reason that once a race car, always a race car?
Because I think what your hypothetical presents is a fundamentally different concept. You're talking about the relationship between something that does not start out as a motor vehicle. Does that stay a non-motor vehicle? Does it become a motor vehicle? Is there an on-ramp into the motor vehicle world? But the issue here is everybody agrees that we're starting out with motor vehicles, and is there an exit ramp from the motor vehicle world? And that touches on a different set of considerations.
I'm not sure we get into it because you might win on standing. So if I could give you a hypothetical about standing, and then I'm going to ask you what you think of it, and then I'm going to ask you to do what I think a lot of attorneys always want to do when they get a hypothetical. I want you to tell me how my hypothetical is different from this case. But first, I want you to answer the hypothetical. Imagine EPA just went on its website, and on Monday, and none of this stuff had happened in 2015, 16, this rule, okay? None of it's happened. And on a Monday, it says the Clean Air Act prohibits converting motor vehicle to a race car when you tamper with the emission systems. And then they get some angry calls. And so on Tuesday, they take that down and they say, what we posted Monday, we took down. It was not intended to represent a change in the law or in policies or practices. Then they say, period. It wasn't necessary to post it on Monday because it's always been illegal to do it under the statute. It's all on the website. And then the racing enthusiasts come and they bring an APA claim and they say, not only are you wrong on the merits, but this needed to go through notice and comment. Would they have standing to bring that APA claim?
If they can show that during...
They say you have now put us through your Tuesday statement where you said we never needed to post what we posted on Monday because it's always been illegal. You've now put us to a dilemma. Comply or risk prosecution. And that's enough injury for us to bring this APA claim to what we'll call an interpretive rule that didn't go through notice and comment. Do they have standing there?
If they can provide specific evidence that they're somehow injured by this, but even if they did have standing.
They say they file a declaration, maybe unlike this case, okay? I mean, I'm not saying that this is a winner case, but unlike this case, they file a declaration. They say we used to be doing this all the time. And after what you said on Tuesday, well, starting Wednesday, we stopped. And we don't want to stop. You've put us to a dilemma. You've put us to the choice of either comply or risk prosecution. And that constitutes final agency action. That's enough for standing. And we get to challenge the merits. And we get to bring our notice and comment claim.
So they may have standing in that case, but I don't know if the Tuesday action is going to be a final agency action.
So what's the difference? So you say they may have standing there. What's the difference between that and this? What are the substantive differences? What are the differences that matter?
Well, there are two main differences. The first is we are not challenging their general standing to sue on the 2016 clarifications. We are just making a very limited standing challenge on their ability to challenge the adequacy of the explanation there. The second problem is that the premise of your question is just not true here because EPA has stated its view that motor vehicles used solely for competition are not exempt from the tampering prohibition. And a footnote 7 of our brief gives examples that goes back decades. And in the regulations before 2016, EPA also made clear that the competition exemption applies only to the non-road world. And I think the thing to remember here is that the default rule is the tampering prohibition. You cannot tamper with emissions controls. And if you want to get out of that prohibition, you need an exemption. And the only competition exemption around was the one for non-road vehicles. And in 2011, EPA amended the competition exemption at 1068-235 subsection B to add the word non-road. And so neither the competition exemption nor any other regulation ever offered an exemption to motor vehicles that were used solely for racing. And without an exemption, those vehicles are subject to the tampering prohibition. And that was true before 2016, and it was true after. So that's why I say the premise of your hypothetical is wrong, and that's a big difference with this case.
In the real world, in this case, the announcement that we're not going forward with the regulation because the law has always been thus was also, I guess, we're told, accompanied by a new enforcement initiative that had never been taken before.
That's not true. In our brief, in the background section of our brief, we've cited examples of enforcement actions that predate the 2016 rule. So EPA has this.
They fall into
across.
They fall into the period. Are they in the period between 2011 and 2016?
I think there was one example before 2011, but the point is they're not challenging the 2011 regulations. And EPA has focused on going after these defeat device manufacturers and distributors for years. It's not like it snapped its fingers in 2016 and says, oh, we're going to go after them now. And if you look at so in footnote 7 of our brief, we also give an example of EPA's presentation at one of the major aftermarket trade shows where EPA got up in front of all these aftermarket producers and said, no, you cannot tamper with motor vehicles, and claims of racing only do not shield you from the tampering prohibition.
Can I ask, you have another regulation which allows motor vehicles to be redesigned into non-road vehicles. How is that possible? Why is it permissible to do that, but to go from motor vehicles to non-road vehicles if you can never go from motor vehicles to race cars? I'm
sorry, which regulation are you referring to?
It is 40 CFR 1039.801 2. It says an engine originally manufactured as a motor vehicle engine or a stationary engine that is later used or intended to be used in a piece of non-road equipment is no longer a motor vehicle or stationary engine and becomes a new non-road engine. So if you're talking about non-road engines, it is not the case that once a motor vehicle, always a motor vehicle.
Just engine.
I'm not familiar with that provision, but what I would say is, I mean, yes, that is talking about engines, and it's the new engine. The engine would, I guess, be regulated as as something else, but we're not. Again, we don't need you to hold that the design of a motor vehicle never changes. What we're talking about here is the kind of competition conversions that the coalition wants to do don't get you out of the tampering prohibition. And I just want to go back to the point about redesign, which I think they seem to be focusing on instead of the competition use. And the other problem with the redesign is that it leads to this absurd outcome where the order in which you make changes really matters. So under their theory, if you first, add the roll cages, add the competition camera, and then you remove the catalytic converter, that's okay. But if you flip the order and remove the catalytic converter first, and then add the competition camera, the roll cages, that's still illegal tampering. And that just can't be right. I mean, Congress was not putting form over substance when it was regulating tampering. Unless the court has any more questions.
Could you read this just as a factual question? Could you
Yeah.
turn a motor vehicle into a non-road vehicle without tampering?
I don't know. I don't know because, I mean, non-road vehicles are so different from motor vehicles. I think you would probably have to do an extensive amount of work. So I don't know. But again, the coalition is not talking about changing their motor vehicles into non-road vehicles, because non-road vehicles also
No, I
have
understand. I understand that, but it does. This probably just goes to standing. It does. There are things in your regulations which tend to at least suggest that before these amendments, the kind of conversion that we're talking about was permissible, at least under the regulations.
Well, I do want to clear that there's some regulations that talk about rebuilding engines, and so that's meant to basically allow you to extend the life of the engine, but there are rules about what kind of configurations you have to leave your emissions controls in.
Just one question on the merits, if we get there. So your position before us is that this kind of conversion is unlawful. But when you adopted these amendments, you declined to adopt a regulation that would have made crystal clear that you can't change a motor vehicle into a race car. You declined to adopt that, and you said the reason you're not adopting that is that EPA supports racing. Which would, so, I mean, that's very clear statement in a very clear proposal that would have made this unlawful. And now you're sort of, through this elliptical interpretation of another reg that's about safety, you're saying, well, we did it anyway. We did it through changing the definition of a motor vehicle. And we have to jump through a lot of hoops to get to the merits, but if we get to the merits, that would seem to be a pretty good indicia that your explanation is lacking here.
So a few points. The first is, you're right, EPA did not finalize the longer statement because people, I think, were confused, and so EPA just decided.
Because EPA supports motorsports. Its focus is not, nor has it ever been, on vehicles built or used exclusively for racing.
That is true as a matter of its enforcement discretion on what to focus on in terms of building. But well, let me just also say, to be clear, EPA does not regulate and has never regulated professional race cars like Formula One, like NASCAR cars. That has never been under the Clean Air Act. What EPA is talking about here is if you want to use your motor vehicle for racing, that's fine, because Clean Air Act does not prohibit racing. What you cannot do is tamper with it. Now, I think as a matter of enforcement discretion, the agency does not focus on individual car owners who want to race. It focuses its enforcement efforts on the defeat device manufacturers and distributors.
So is it fair to say then that in the past, racing was conducted by using automobiles that were stock cars when bought and had been modified through tampering, and racing going forward will be changed in that they will be unmodified.
So it's true that in the professional racing circuits, many decades ago, started out as, production cars, but for a long time now, if you look at NASCAR, you'll see that those are specifically built for racing, not just for racing, but for specific circuits rules. There are NASCAR rules, there are Formula One rules. And those cars are nothing like the vehicles you see on streets. I mean,
So
they're
not manufactured by the same companies that manufacture the street vehicles?
They are sometimes, yes, they are manufactured by the same companies, but they use completely different designs. So for example, I think the latest NASCAR series have Toyota Camry. They're the Cup Series Camrys and they're designed differently. They don't have doors, for example, because doors are apparently a big liability in high-speed crashes. And so that's why you see NASCAR drivers getting in and out through the window. Well, that's not going to work in your street car because you're using your cars to transport people and things on public roads and you need doors. So that's one example of how very different these professional race cars are from the cars that you and I drive on the streets.
So those cars, when they are first built, are certified motor vehicles or not?
Which cars?
Ones you're describing with, let's say, no doors.
Those are not certified at all. They're not regulated by the Act because they're not designed for transport on public roads.
Those have been used until now, until before the change in enforcement policy, and they will continue to be used. Is that correct?
NASCAR cars will continue. I mean, I guess unless Congress amends the Clean Air Act, NASCAR cars have never been regulated under the Clean Air Act.
So what is it? What set of vehicles is it that are experiencing a change in enforcement policy?
I don't think there is a change in enforcement policy. EPA has been looking.
So what is the nature of the cars that you're concerned about if it's not the ones that were built for and are used for racing? There's another set apparently of things that were more like stock cars and then were adapted, or is it the ones that were built for racing and were changed?
I see. Okay, let me just explain what we're actually disputing here. We're not disputing the NASCAR cars and the Formula One cars because those are out of the Clean Air Act.
The Formula One cars I've seen, they don't even look like cars. Right?
I know, exactly.
They couldn't go on the road. They go, I don't know, a few hundred meters or something.
Well, there are probably state laws about what kind of cars you can actually drive on the road. Under the Clean Air Act, they're not regulated. Formula One cars, NASCAR cars, not certified. They don't have to have emissions controls, period. Now, what we're talking about is a very small group of things called motor vehicles, right? Those are things that you generally see on streets that they're your passenger cars, your pickup trucks, that sort of thing. And everybody here agrees that as a general matter, it's illegal to tamper with motor vehicles, vast majority of which don't race at all and are properly subject to the tampering prohibition. The coalition also agrees that a motor vehicle is not exempt from the tampering prohibition just because it competes in races. If they go on public roads at all, it's illegal to tamper with them. So the only kind of vehicles that the coalition says it cares about are motor vehicles, so like your, Camrys and Accords and whatnot, that are used solely in competition and that never drive on public roads. Now, there's just no indication that.
And these are cars that were designed, as you were describing, never to go on public roads?
No, these start out as motor vehicles. They're like the passenger cars you buy from your dealer that you use for commuting, for picking up the kids. And on page 11 of the opening brief, the coalition makes clear that that's the kind of cars we're starting with, and that's the kind of car they want to convert into race cars or use solely for racing. And we're saying, no, those cars, those kind of use, the kind of conversion they want to do does not exempt that motor vehicle from the tampering prohibition.
So Ms. Broom started out telling us about a recent race in Florida. Which kind of cars would have been involved?
those are Formula One cars. They are professional race cars that are never regulated by the Clean Air Act.
And totally unaffected by the discussion we're having.
Correct.
What's your policy concern? If you're willing to allow Formula One cars that presumably spew massive amounts of gasoline into the air, what do you care? Why would you care if someone takes an ordinary car and turns it into something a little bit more like that? Is it that that vehicle can then be used on the roads after the race?
Yes. Well, that is one concern. Yes, because I mean, frankly, you can race your passenger car and make some conversion, say I'm racing, but there's nothing to stop you from taking it onto public roads again. And I think so. There are two issues here. One is that just if you consider the statute's structure, there's really a pretty specific mechanism by which Congress used to regulate motor vehicle emissions, and that's in two stages. So on the front end, you have the burden that's put on the automaker to meet the emission standards. They have to install emissions controls and show that those controls work. And then on the back end, Title II safeguards the automakers' upfront work by telling everyone they can't tamper with those controls. And so this back end protection is really crucial to the regulation of motor vehicle emissions. The other thing I'll say is that it's not just our policy, it's Congress's decision. I mean, Congress has had multiple opportunities to regulate motor vehicles differently from non-road vehicles, to shield motor vehicles that are used solely for racing from the competition from the tampering prohibition, and it never did that. And so we have to follow Congress's policy on this.
Well, I was intrigued by Judge Katsas' question a few minutes ago about the statement that the EPA supports amateur racers. If you view them as lawbreakers polluting the environment and defying the will of Congress, why do you support them?
We support racing. We do not support tampering. And the Clean Air Act does not prohibit.
Would it have been more accurate to say the EPA supports amateur auto racers who race in a way that currently no amateur auto racers race?
I don't think that's true, that currently no auto racers race without tampering. I think there are races that set rules about what kind of emissions controls you have. I mean, but I think the bottom line is EPA supports racing. That's what it was trying to say in that statement. But and I think, our rule, I think, as Judge Ginsburg points out, it doesn't disadvantage race car drivers as to each other. It doesn't tell some people you can't tamper with your motor vehicles and others.
It does tell people, Jen, it does tell people who want to drive really fast that they can't drive as fast as they want. I mean, the whole point of racing is to drive as fast as to drive fast, right? I mean, they could have chosen to play like dice if all they cared about was competition.
Well, even NASCAR has a lot of rules about what you can do to your cars. And there are safety rules for those cars as well. So it's not true that, the only thing that everybody cares about is to drive as fast as possible.
No, but I mean, this statement was made in the context of explaining rejection of a rule that would have clearly resolved this precise question about tampering.
Well, I think, there are comments where people were confused about that rule, and EPA said, all right, we don't need this rule. Let's not make things worse. And EPA wanted to clarify that for people who thought that it was cracking down against racing as such, or, professional racing, that no, it was not doing that.
Good. Okay. Thank you, Ms. Chen.
Thank you.
Ms. Broom, we'll give you 2 minutes.
Thank you, Your Honor. So I do want to just briefly touch back on standing and refer the court to Grocery Manufacturers Association versus EPA. And in that case, the court said that where standing is self-evident, that we do not need to do that. If you look at Mr. Pooley's declaration and you look at 1068.235, which is redlined at page 29 of our opening brief, they say, but not for motor vehicles. And that is Mr. Pooley's business, and he was harmed by that addition to the regulations. I would also note, yes.
I think you said earlier that the court accepted or requested supplemental information about standing.
Pardon me?
You say earlier that the court received accepted supplemental.
That was in the, I'm sorry, that was in the Chicken Council case, and I can get you the site on that. I think that was also in Grocery Manufacturers, but I can get you that information, Your Honor, if you like.
I think we can find it.
Okay. With respect to Ms. Chen's statements about the 2011 rule, in 2011, EPA Part 1068 only addressed, had only addressed non-road vehicles. So that explains why that change was made then. And it was not addressing converting motor vehicles into race cars. So that's a red herring. I would also say that that this is not a case about tampering, it's about the definitions. And so, and her view that, and EPA's view that it's NASCAR and Formula One and that's it, is an elitist view of the world. The vast majority of racers in this country are working on their stock cars. And if you think about what Congress said, which I'm so glad that Ms. Chen raised, back in 1965, NASCAR was production vehicles, as Your Honors pointed out. And so it makes no sense to say that Congress prohibited this in 1965 in the face of, they are arguing with reality. And so substantively, I respectfully submit that what they have done is inconsistent with what Congress intended and what Congress said.
On the statutory question, I was kind of focused on the word design and thinking, just as a conceptual matter, it's perfectly plausible to imagine a redesign. But what's your response to EPA's point about the tampering rules, and that the tampering rules prevent, by their terms, exactly what it is you would have to do in order to effectuate a redesign? It's not so much that conceptually you can't redesign a motor vehicle into a race car. It's just that you can't do that under the tampering rules.
I mean, I think those are issues that EPA could have discussed if it was having a non-arbitrary and non-capricious rulemaking. There's none of that.
Answer. That's just what the statute does and has always done.
In the record, exactly. And also that they, the fact is once you decide to make it a race car, then you can't drive it on the street anymore. And there are objective indicia of that. And so there are things that EPA could bring in an enforcement case, but what it wants to do is not to have to prove any of that in the enforcement case, and instead just say that if I offer for sale a part that could be used on a vehicle that has a certification, then that is that puts me in the position of effectively a distributor of illegal parts, and that's prohibited under Clean Air Act Section 203 A3B. So,
Judge Ginsburg. Okay, thank you very much. The case is submitted.
Thank you, Your Honor.